If you think you understand what happened when Trump showed up at the Supreme Court, you probably got it backwards. Because the viral title that is circulating right now says, "A Supreme Court justice walked out after Trump insulted the Constitution," live. That is not what happened, and the real story is actually far more significant than the clickbait version. Because a Supreme Court decision is expected any day now that could deliver one of the most consequential defeats of Donald Trump's presidency. And if you are getting your information from a sensationalized YouTube title, you are going to be completely unprepared for what is coming. So let me tell you what actually happened. Subscribe right now because the Supreme Court decision in this case is expected before the end of June 2026. That is days away. And when it lands, you need to understand exactly what it means and why it matters. Here is the reality behind the viral title. On April 1st, 2026, Donald Trump became the first sitting president in American history to attend Supreme Court oral arguments in person. No president had ever done it before. He sat in the front row of the section of the courtroom reserved for the general public. He watched as his own Solicitor General, D. John Sauer, tried to convince 9 Supreme Court justices to accept an entirely new reading of the 14th Amendment. And for the first 90 minutes of the session, he watched 7 of those 9 justices dismantle that argument piece by piece. Then Trump walked out. Not a justice. Trump. He exited the courtroom about halfway through the proceedings, 5 minutes into the opposing side's argument. Audible murmurs rippled through the gallery as he left. He slipped past the heavy brass gates and marble columns and was gone. The justices stayed. The argument continued. The court kept doing its job. So when you see a title saying "A Supreme Court justice walked out after Trump insulted the Constitution" live, understand that the title has inverted the facts. The person who walked out was the president, not a justice. And the most prominent public insults toward the justices came in Truth Social posts that Trump published days after the hearing, not during a live confrontation in the courtroom. The viral version of this story is backwards. The actual version is more significant, more constitutionally important, and more relevant to decisions that will affect every American. Let me explain it properly. On January 20th, 2025, his first day back in office, Donald Trump signed an executive order purporting to end automatic birthright citizenship. The order declared that children born in the United States to parents who are undocumented immigrants or who are present on temporary visas would not automatically be citizens. This was an attempt by the executive branch to reinterpret the 14th Amendment to the Constitution without an act of Congress, without a constitutional amendment, and without any court ruling supporting the reinterpretation. The 14th Amendment states plainly, "All persons born or naturalized in the United States, and subject to the jurisdiction thereof, are citizens of the United States." That language has been understood to confer birthright citizenship since the Supreme Court's 1898 decision in United States versus Wong Kim Ark, a case involving the U.S.-born child of Chinese immigrants. That 128-year precedent was what Trump's executive order tried to unilaterally overturn on day one. Every federal court that reviewed the order struck it down. Not one court upheld it. Multiple federal district courts issued rulings blocking the order before it could take effect. The order has never been enforced for a single day. The Supreme Court agreed to hear the case, which is called Trump versus Barbara. The name Barbara comes from the pseudonym given to a Honduran woman living in New Hampshire who was pregnant when the order was signed and challenged it to protect her unborn child's citizenship status. Oral arguments were held on April 1st, 2026, before a packed courtroom that included Trump himself, Attorney General Pam Bondi, Commerce Secretary Howard Lutnick, Academy Award-winning actor Robert De Niro, who attended as a Trump critic, and a gallery of reporters, lawyers, and members of the public who had lined up for hours to witness a genuinely historic moment. Hey, 73% of people watching right now are not subscribed. The Supreme Court decision in this case is expected before the end of June 2026. That is potentially days from now. When it lands, it will be headline news. Subscribe right now so you understand what the ruling actually says, instead of having to rely on someone else's summary. Let me walk you through what happened inside the courtroom because the substance of the argument is what actually tells you what the decision is going to say. Solicitor General John Sauer argued on behalf of the Trump administration. His core argument was that the phrase "subject to the jurisdiction thereof" in the 14th Amendment should be read narrowly. He argued that people who are in the country illegally or who are here temporarily on non-immigrant visas are not fully subject to American jurisdiction in the way the amendment's framers intended. Therefore, he argued, their children should not automatically receive citizenship at birth. To support this reading, Sauer pointed to the Civil Rights Act of 1866, which preceded the 14th Amendment and used slightly different language. He argued that language should inform the reading of the amendment. He also argued that we are in a, quote, new world, one where birth tourism, the practice of foreign nationals traveling to the United States specifically to give birth so their child will be a citizen, is a modern reality the amendment's framers could not have anticipated. What happened next is the most talked-about moment of the Supreme Court's 2026 term. Chief Justice John Roberts was not impressed by the New World argument. He told Sauer directly, "It is a new world. It is the same Constitution." That sentence, calm and precise and devastating, drew audible laughter from the courtroom gallery. In 5 words, Roberts destroyed the central premise of the administration's argument. The Constitution does not change because modern circumstances are different from 19th century circumstances. The text means what it says, and what it says grants citizenship to those born on American soil. But Roberts was not alone. Justice Neil Gorsuch was described by multiple reporters in the courtroom as audibly hostile toward the government's position. Gorsuch questioned Sauer's reliance on Roman law sources and obscure historical citations, pointing out that more authoritative and relevant sources cut directly against his argument. Gorsuch even quoted Justice John Marshall Harlan, who had dissented in Wong Kim Ark in 1898, but who later delivered a lecture explicitly acknowledging that the ruling in that case covered children born to temporary visitors in the United States. Even the justice who had disagreed with the precedent conceded what it held. Justice Kavanaugh pushed back against the administration's attempt to use European countries as a reference point. "We try to interpret American law with American precedent based on American history," Kavanaugh told Sauer. "Why should the court be thinking about what other countries do?" Justice Amy Coney Barrett pressed Sauer on practical impossibilities in the administration's position. She asked him what would happen to a child born to a victim of human trafficking who had been brought to the United States illegally. Would that child be denied citizenship? Sauer could not give a clean answer. Barrett also highlighted what she saw as an unworkable test. If a child's citizenship hinges on a parent's domicile and intent to stay permanently, she told Sauer, then you would have to adjudicate both residency and intent at the moment of every birth. What about foundlings, children with no known parents? Yeah, but what about the Constitution? She asked. Justice Jackson asked Sauer how citizenship would even be determined at birth under his proposed rule. He suggested Social Security systems would make an initial determination, and parents could sue if they disagreed. Jackson seemed deeply skeptical. Sotomayor raised concerns about historical precedent. She noted that when the Supreme Court had previously ruled that Native Americans could not automatically become citizens, the federal government began denaturalizing even those who had already acquired citizenship. She was clearly warning about the chaos that would follow from any ruling that began unraveling birthright citizenship. At the end of Sauer's argument, when the opposing side's attorney, Cecilia Wang of the ACLU, stood up to argue in favor of birthright citizenship, that is when Trump walked out. He had been in the room for approximately 90 minutes. He stayed for the part of the argument where his side was speaking. He left when the other side began. He went on Truth Social shortly afterward and wrote, "We are the only country in the world stupid enough to allow birthright citizenship." That post, and the ones that followed, revealed that Trump understood the argument had not gone well for him. He had previously predicted in February that the court would find a way to come to the wrong conclusion on citizenship, just as it had when it struck down his tariffs. After those tariff rulings, Trump had publicly called the justices who voted against him unpatriotic and disloyal. He had called them an embarrassment to their families. After the April 1st birthright citizenship hearing, he attacked the court again on Truth Social. He wrote, "The country can only withstand so many bad decisions from a court that just doesn't seem to care." Let me put the significance of those attacks into context, because they matter beyond the politics. The President of the United States publicly calling Supreme Court justices unpatriotic, disloyal, and an embarrassment to their families is not normal. It is not precedented in modern American history. Justices are appointed for life precisely so they do not have to make decisions based on fear of political consequences. The independence of the judiciary from the other branches of government is a foundational principle of the constitutional system. It is what separates a constitutional republic from a system where the powerful simply get the outcomes they want from courts. When the executive branch attacks the legitimacy of the judicial branch for making decisions the president dislikes, it creates a systemic pressure that the founders specifically designed the Constitution to prevent. Roberts has pushed back against this pattern before. In 2018, when Trump called a federal district judge an Obama judge, Roberts issued a rare public statement saying, "The United States does not have Obama judges or Trump judges or Bush judges or Clinton judges." He said, "What we have is an extraordinary group of dedicated judges doing their level best to do equal right to those appearing before them." That statement was extraordinary coming from a Chief Justice. The April 1st quip, "It is the same Constitution," served the same function. It was Roberts sending a message in public, on the record, inside the courtroom. The law does not change because a president wants it to. Now let me tell you what happens next, and why you need to be paying attention right now. A decision in Trump versus Barbara is expected by late June or early July 2026. That is days away from this recording. Based on what was said at oral argument, the outcome appears clear. 7 justices expressed skepticism toward the administration's position. Only Thomas and Alito asked questions that were sympathetic to the government. For the administration to win, it would need to flip at least 3 of those 7 skeptical justices from what they signaled at argument to ruling for the administration in the decision. Oral arguments do not always perfectly predict outcomes. Justices sometimes ask hard questions of both sides. They sometimes rule differently than their questions suggest. But a 7-2 expressed skepticism at oral argument, combined with Roberts' pointed public rebuke, is an unusually clear signal. The independent legal analysts, the reporters covering the court, and the legal scholars who wrote about the April 1st argument are nearly unanimous. Trump's birthright citizenship order is going to be struck down. If and when that happens, here is what it means. The order that was signed on day 1 of Trump's second term, one of the centerpieces of his immigration enforcement agenda, will be permanently invalidated. Every child born on American soil will continue to automatically receive American citizenship, just as they have for 128 years since Wong Kim Ark. The administration will have no further legal avenue to change that through executive action. Changing birthright citizenship would require either a constitutional amendment, which requires 2/3 of both chambers of Congress and ratification by 3/4 of the states, or a reversal of Wong Kim Ark by the Supreme Court itself, which this case makes less likely, not more. The precedent will be affirmed, the executive order will be nullified, and the pattern of presidential attacks on the judiciary will have produced no legal benefit for the president. What is the broader lesson of all of this? It is not that Trump lost at the Supreme Court. Presidents lose at the Supreme Court regularly. It is that the spectacle of the most powerful person in the country sitting in the audience of the court that was about to rebuke him, watching 7 justices systematically take apart his legal position, and then leaving before the other side had finished speaking, reveals something important. The constitutional system is not easily dismantled by a single election or a single executive order. Courts appointed by different presidents, applying legal tests developed over more than a century, continue to operate by their own rules. And when a president publicly attacks the justices for doing their jobs, the justices do not fall in line. They issue quips about the same Constitution and continue the argument. The viral title about a justice walking out is wrong. The real story is about a president who attended the Supreme Court for the first time in history, watched his argument fail in real time, walked out himself, and then went online to attack the court. And the court, following the same Constitution, is about to issue a decision. Subscribe right now, because when that decision drops, I will have complete coverage and analysis within hours. You need accurate information, not viral titles, to understand what is actually happening to the constitutional structure of this country. And please remember, this is educational content only, not legal advice. Always consult qualified legal professionals for guidance on any legal matter that affects you personally.